Good afternoon, good evening, everyone. My name is Tom Warwick, and welcome to the Atlantic Council and a discussion about an important issue that has gotten increasing attention over the past several years. We're looking to how we avoid a transatlantic security crisis in the looming battle over passenger name records. To discuss this subject today, we have three very distinguished American experts who are going to be discussing a number of aspects of this important question. We'll have Ken Propp, who's a non-resident senior fellow here at the Atlantic Council. He is the adjunct professor on European Union law at Georgetown University. We have Ambassador Nathan Sales, also a non-resident senior fellow here at the Atlantic Council. He is the former counterterrorism coordinator and ambassador at large in the State Department, who has worked on these issues at two cabinet departments, the Departments of Homeland Security and the Department of State. And finally, we have Frances Burwell, one of the leading scholars in the United States on European and transatlantic affairs, who will be bringing her expertise to bear on how this particular issue is addressed. Before we begin our discussion today, I'm going to take a couple of minutes to explain to those who might not be aware what a passenger name record is. Ever since the terrorist attacks against the United States on September 11, 2001, there was the recognition that not enough was done to understand who is flying on airplanes, especially internationally. The predecessor to Customs and Border Protection, a component of the Department of Homeland Security, had been collecting passenger name record data and another form of data called advanced passenger information on a voluntary basis, just to try to keep track of who was coming in or going out of the country. It was recognized that had API, as it's called, and PNR, as passenger name record data is called, had API PNR data been collected and properly analyzed by experts, it's quite probable that 17 of the 19 hijackers on 9/11 would have been identified as such to US counterterrorism and law enforcement professionals prior to the attack. This served as a wake-up call, and as we'll get into in just a minute, this became mandatory. The advanced passenger information is fairly straightforward. That's your passport data, and that's collected by airlines when you check in. Passenger name record data is essentially the airline's business record of your reservation and includes whatever information a passenger gives to an airline. And that can include your name, your telephone number, your address. It'll include your travel itinerary and other kinds of information. Now, obviously, passport information is good for catching terrorists or criminals if they are known to law enforcement or Homeland Security officials. But it turned out, especially after 9/11, that PNR data turned out to be a very rich source of information about previously unknown terrorists or criminals who might be trying to travel internationally. And with that as an introduction, we will first allow me to ask a question of Ken Propp, because Ken, as somebody who's worked on this issue both as a government official and as a legal expert on these issues, can you give us an outline as to how we got to this situation where there's an issue in the transatlantic relationship over PNR data and why this issue is important?
Thanks, Tom. Um, First, let me step back and put this in a slightly broader context. Um, there has been a struggle going on over 2 decades between the US and the European Union to settle the terms on which personal data can cross the Atlantic for use in multiple contexts, commercial, law enforcement, and broader national security. Right now, the highest level of attention is being given to commercial data transfers since the invalidation of the Privacy Shield data transfer agreement last summer by the European Court of Justice. There is also a data transfer agreement that relates to international bank messaging information, so-called SWIFT data, that has been in place for over a decade. And that information is very valuable for tracking terrorist financing transactions. So transatlantic PNR exchange fits very much into this continuum. It has been controversial in the past. Recently, it has been less visible, but now the issue is back with us. And let me explain why that's the case. So when the Congress put into U.S. law the requirement that PNR data be transferred from airlines flying to the United States to the U.S. government, that immediately raised a question for the airlines under European privacy law, because there has to be a particular legal basis for that information to be transferred to the United States. The airlines were happy for the information to come to the United States, but they turned to the European Union to figure out what that legal basis would be. The US government negotiators thought, well, passengers consent to this when they purchase an airline ticket. But the EU view was no, that consent relates to the airline's commercial use of the data and not to the US government's use of it for security purposes. That's a different purpose. And voluntary consent is not possible in a situation where the only alternative is swimming across the Atlantic. I was in the room when that was explained to the US government, and I can tell you the consternation on the face of some of the US government lawyers at the time. The result was an international agreement in which the EU itself agreed to consent to the transfer of the data from its own territory. And in return, the US government agreed to provide privacy protections that largely corresponded to EU privacy law. We'll come back to that point about the extent to which they correspond to EU privacy law in a moment. The agreement initially reached in 2004 was subsequently replaced by another agreement in 2012 that has proven to be more durable. It has largely functioned well. Other countries noticed it. Canada and Australia reached their own agreements with the EU. There was also significant action at the international level. In 2017, the UN Security Council adopted unanimously a resolution requiring countries to develop and use PNR systems, and the International Civil Aviation Organization subsequently adopted quite detailed PNR standards and recommended practices on a multilateral basis. The EU itself, in 2016, mandated that its own member states adopt their own PNR systems for intra-EU flights and for many flights originating from outside the EU as well. But there are still, it must be said, significant critics of PNR collection, particularly in Europe. They live in the European Parliament, notably, and in 2015, they brought a case against the draft Canada PNR agreement to the European Court of Justice. And 2 years later, the court ruled that significant features of that agreement were not consistent with the EU's Charter of Fundamental Rights, which is a binding constitutional level instrument in the EU treaties that has essentially an equivalent status to the US Bill of Rights. I won't go into all the provisions that the court found insufficient, but the long and short of it was that it sent the Commission back to the negotiating table with Canada And almost 4 years later, they still have not completed negotiations with Canada. So that's how difficult a process this continues to be for the European Commission. And then just a few months ago, the European Commission acknowledged publicly that the agreement with the United States had many of the same deficiencies as the agreement with Canada. They noted deficiencies in the retention of PNR data, the processing of sensitive data, notification to passengers, independent review of the use of PNR data, and a number of other features. Now, it should be said that the Commission otherwise has been publicly supportive of this agreement with the United States. It has continued to operate without interruption. So the Commission is struggling here. They have launched an internal consultation process where they are looking for a new approach to international PNR sharing, one that appears to focus on the ICAO approach. We can talk more about that perhaps as the hour goes on. There's also a legal challenge to the EU's own PNR law that's currently before the Court of Justice. So to conclude, this is really a complex and murky picture in Europe, both legally and politically, with complex dynamics between the various institutions in the EU and with many of its member states who are quite supportive of PNR. But from the perspective of the United States, there is a looming threat, which is that the Commission, before long, has to take account of the binding jurisprudence of the Court of Justice, and the US government obviously is going to have to respond. I'll stop there, thanks.
All right, thank you very much, Ken, for setting that up for us. I do encourage people, if you have questions along the way, please type them in the Q&A function that you'll see at the bottom of the window on your computer screen, laptop, or cell phone. And we'll be picking those up at around 12:40 Eastern time. Ambassador Sales, let me turn to you next, because as I said at the outset, you have the unique position of having worked on these issues at two cabinet departments, and you therefore have a unique perspective on the importance and indeed international practice regarding collection and use of PNR data. What are, in your view, some of the most important things that people need to know about recent developments in practice in this area?
Well, thanks, Tom, for the question. And Ken, thank you as well for that comprehensive laydown of the current state of play. I want to highlight a couple of things that Ken mentioned in his remarks that I think are really quite significant, because in the past 5 years, I think what we've seen in the international community is a real convergence on PNR. The use of PNR has really become an internationally accepted and, in a sense, internationally mandatory best practice for border security and law enforcement and counterterrorism. Let me just briefly highlight and elaborate on a couple of the key developments. I think the first, chronologically, and even beyond chronologically, perhaps the most important that we need to take account of is in 2016, the European Union adopted its own directive mandating that all EU member states develop and deploy PNR systems. The reason why that's so important is because for many years, the United States was sort of an outlier in its use of PNR. It was an early adopter of this tool. It had used it in one form or another even before the 9/11 attacks, but certainly after the attacks on the homeland, the United States became even more devoted to developing more refined, more capable versions of these systems to screen passengers entering the United States. In 2016, remember the context. The European Union is considering this issue in the aftermath of the 2015 Paris attack as well as the spring 2016 attacks on transportation infrastructure in Brussels. And it was apparent to EU leaders as well as EU member states that the European Union and its member states had no reliable mechanism to track the movement of suspected terrorists into or out of European soil. And in the wake of Paris and Brussels, that was no longer an acceptable status quo either to European citizens or to leaders at the national or EU level. And so in 2016, the European Union adopts a directive on PNR. There's actually a sense, an underappreciated sense, in which the EU directive goes even further than the American approach when it comes to PNR, because in the United States, we generally limit the collection and analysis of PNR data to flights that are international in nature, to the United States, from the United States, or over US territory. The EU directive is, perhaps to the disappointment of our American colleagues, more ambitious in that it also mandates the use of PNR systems for what we might consider to be domestic flights, that is to say, intra-European flights. So maybe the Americans have something to learn from our transatlantic brethren. The second major development that I think reflects this sea change in global attitudes towards PNR is UN Security Council Resolution 2396, adopted in late 2017, and which has already been mentioned several times already. UNSCR 2396 is, in my opinion, the most important resolution the Security Council has ever adopted on terrorist travel, in part because it mandates that every UN member must develop and deploy the sorts of systems that the Americans and now the Europeans have been using to secure their own borders. PNR is no longer discretionary. It is, in a sense, a matter of binding international law that UN members must adopt and use these systems. And then the third and final major development that I would highlight is ICAO in 2020 adopted standards and recommended practices. ICAO is, of course, the International Civil Aviation Organization. It is the UN's body for regulating commercial flight, the safety of flight, the security of flight, and so on. The standards and recommended practices that ICAO adopted were designed to create, in a sense, a roadmap for countries that have an obligation to develop PNR systems, but don't necessarily have the wherewithal, the technical or policy expertise to do so. And so those standards lay out in rather elaborate detail what design features countries should take into account as they build their own systems. There's two features of these standards that I think are particularly important as they relate to the transatlantic conversation about bilateral PNR agreements. The first is retention, and the second is what we might call a non-interference principle. The ICAO standards are quite clear that countries, when deploying PNR systems, should retain the PNR data that they collect for as long as it's relevant to an ongoing inquiry or investigation. That is to say, ICAO has recognized that the data doesn't lose its relevance the moment a passenger arrives or departs. In many cases, that data might be irrelevant, seemingly irrelevant, until some point, a year, 2 years, 3 years down the line, when additional developments cast it in a new light, and it takes on an additional investigative value. So ICAO recognizes the importance of keeping the information for as long as it may prove to be useful to investigators. And then the second principle that I think is important to flag is, again, what we might call a non-interference principle. The ICAO rules call on member states to refrain from imposing sanctions on airlines that are complying with ICAO standards. We can talk about how Europe might view that particular requirement in the Q&A or as the panel proceeds, but the basic idea there strikes me as a very important one. We should not put private actors, such as airlines, in a position where they are risking liability on one side of an international flight because they are caught in the crossfire between different regulatory requirements by different sovereigns. And the ICAO principles are reflect the idea that we should try to leave the airlines out of any policy disputes between nation states or transatlantic partners. Tom, let me stop there, and I'll look forward to continuing the conversation.
Thank you very much, Nathan. Again, a reminder, give us any questions you may have through the Q&A function. Dr. Burwell, Ken and the ambassador have sort of set up the issue and the potential conflict. In other words, airlines, if they want to fly in or out of the United States, have to provide passenger name record data to the US government, to the Department of Homeland Security. On the other hand, if airlines want to avoid step fines that would make their entire business unprofitable, they need to comply with European privacy directives. So how, given the situation that was created by the Court of Justice opinion, how do we get out of this? How do we reconcile the seemingly irresistible force and the seemingly immovable object?
Well, I think that since we've had numerous diplomats working and lawyers working on this for the past few years, I'm not going to be able to come up with a solution in the next few minutes, but let me just put a couple of thoughts on the table. First off, the digital economy between the United States and the EU is of growing importance in our economic relationship. It is the growing part of our economic relationship, and therefore any rules, any arrangements that we make between ourselves that have to do with data transfers, et cetera, are only going to become much more important in the future. So the time to think about this is now, because it's not sustainable to go forward without a better basis for the transfer of data. Secondly, I really put this particular issue in the same basket as the current discussion over Privacy Shield and data transfers between the US and the EU. There are peculiarities, but there are also strong similarities. And I think the main one is that this is part of a larger collision between national security issues, especially but not exclusively anti-terrorism, and privacy. And I think, you know, it's good for us to remember in the United States that Europe has been the victim of terrorism, perhaps certainly more frequently, and with a not insignificant cost. They have a real interest in fighting terrorism as well. But this is something that every democracy struggles with. This is not just a US issue and a European issue. Every democracy that tries to deal with this issue faces challenges, and we'll probably see even more challenges as PNR spreads around the world. The EU itself is struggling with its own member states, some of whom have quite extensive surveillance, national security surveillance powers in their own government, and they use them. And they have used them for anti-terrorist purposes, as we saw post the Paris bombings. However, they're able to because there's a national security exemption in the treaties of Europe. So they get a bit of a pass, if you will. And another shoe that hasn't dropped yet is what will happen with the UK. What happens between PNR and the UK, which also has extensive surveillance powers. We've just seen that in the case of data transfers, that the UK has been given an adequacy determination, but not everyone in Europe is happy with that. So we can see some rough seas ahead, in particular on that. I think as we look forward to the summit next week, I think that we cannot expect that we will see this issue resolved by then. There had been some hope that the data transfers issue, the Privacy Shield issue would be resolved, but even now what we're looking at is potentially a political statement from the leaders, which will reaffirm their commitment to engage on this issue and to find a resolution. I think that in itself is important. That's a good first step. And I think if we can get it to apply to PNR as well, I think that this would be something that would be worthwhile. Because we do, in some cases, these issues, you're caught. You don't want them to be noticed because people might actually demand that there be a resolution, and you've been kind of going on knowing that there's an issue. But other times you actually need things to come to, I hesitate to use the word crisis, but to come close to a crisis in order to be resolved. The other, of course, strategy is to enlarge the discussion. And here I think that with more and more countries using PNR, but particularly those who have significant surveillance capabilities, there needs to be more of a discussion about what is acceptable, so that it's not just the Europeans accusing the United States of having unacceptably broad surveillance powers, but rather it is all of the like-minded countries coming together and working on trying to figure out how you balance this between the need to know certain things to preserve the security not only of aircraft in the air, but of communities generally, and the preservation of individual privacy and freedoms. And I think, you know, the US and Europe, we're having this argument, but we actually are pretty close to each other. We are like-minded democracies, allies and partners. There are many other states, governments around the world who do not have the same foundations of privacy and individual liberty that we have. And so while we're having this, if you will, dysfunctional intra-family fight, it's much more important that we establish standards for how that data is used if you are flying to China or someplace else, for example. So I think what I am hoping is that the US-EU summit, which will also look at a whole raft of other digital issues, and we have a bunch of them right now because the EU is launching basically a tsunami wave of regulatory proposals in the Digital Services Act, the AI regulation, the Digital Markets Act, and Data Governance Act, to name just 4 of the ones that are on the agenda right now. So we, the United States and Europe, need to have a much stronger dialogue about digitalization, digital regulation, and technology. What is the level of risk that we both can tolerate, and how do we make sure that we're working together rather than working separately and letting others take on, become the writers of the digital rule book. I'm hoping that the summit next week, which, let's be realistic, is not going to resolve all these issues, but I'm hoping that it will be the launching pad for a continuing high-level dialogue. One of the biggest issues of the last few years was the lack of engagement by the United States as the EU was going and starting to think about these issues and drafting proposed legislation itself. We need to be in an early stage, and we need to be working together to make sure that we have the right kind of perceptions. And I think only through this kind of evolutionary process can we get to resolving some of these crucial issues, such as Privacy Shield and PNR, and how we provide the protections that we need for national security, anti-terrorism reasons, and how we balance those with the rights of individuals. So I'm hoping that we will see the establishment next week of a digital council or tech and trade council, whatever you call it, some high-level forum that will provide oversight for these issues and provide the political impetus to get them moving towards resolution.
Thank you very much, Dr. Burwell. Ken, let me turn to you because Dr. Burwell mentioned a very important concept that sort of undergirds the EU approach to privacy and to PNR data sharing, among other issues, and that's the concept of adequacy. Can you explain to folks what adequacy means in this context and why it plays such an important role? And in fact, one of our audience members has posed the question of, well, wasn't Canada considered adequate? So why didn't that solve the problem? What is the background on what this important concept means?
Sure. Let me first say that I think Fran's point about establishing some type of digital forum is crucial here, because PNR is a perfect example of an issue that does cut across areas of competence within the U.S. government. It obviously is of importance to security, but it also has commercial importance as well. And on the European side, it cuts across both interests of the European Commission as well as member states. So coordination on a transatlantic basis here is obviously key. The EU is in a reflection period right now on this subject, and it's important that the U.S. government take advantage of that. On the question of adequacy, which has been asked by, I should note, someone who was a foremost privacy law expert himself for the U.S. government at the State Department and DHS, John Croft. It's a good one. Adequacy means that the EU will only allow data to flow to other countries whose privacy laws are, as the Court of Justice has defined it, essentially equivalent to those in Europe. That doesn't mean identical, but as the cases have evolved over the years, it has become fairly prescriptive. And so what that means is that when the European Commission sets out to negotiate international agreements, they have to look very closely at a foreign country's privacy laws. They essentially have to do a lot of research and make their own judgments, and then know that those judgments are going to be second guessed at the Court of Justice by judges who are themselves not experts in foreign law. So that is the challenge of the system. And it is particularly difficult when one gets into areas like national security, where laws are often not completely transparent. And I would add that that's the easy case with democracies. How the European courts are ever going to evaluate these laws with respect to authoritarian countries with which it exchanges information is an interesting and open question.
And so, Ambassador Sales, in terms of the importance of PNR data, one of the questions that has come in says, you know, is it really that important? If this is going to be an issue that causes a clash of views between democracies, can we not simply not worry about this? What can you say, based on your experience, about the importance of why PNR data needs to continue to be collected, and why therefore we do have to, in effect, grasp this nettle and address it, perhaps using one of the means that Dr. Burwell has identified, as opposed to just agreeing to disagree on this? Is PNR data that important for security purposes?
Well, yeah, it really is, Tom. It's a great question. And I think the answer that the Americans would give is the exact same answer that the Europeans would give, as reflected by the 2016 EU PNR directive. This is an absolutely central counterterrorism and national security tool. Tom, in your opening remarks, you mentioned that it's possible to use this technique to do some, Monday morning quarterbacking, looking back at the flight patterns associated with the 9/11 hijackers. We could have identified the links between 17 out of the 19 hijackers. And that's not to say that we necessarily would have stopped the plot in time, but I think our chances of stopping a plot like that are much greater if we have a PNR system in place than if we don't. A more recent example where PNR was not just hypothetically useful, but actually played an enormously consequential role in a real-time investigation involved the Times Square bombing from several years ago. I'm sure many on this call will remember it. A man named Faisal Shahzad rented, I think it was a Nissan Pathfinder, and set a bomb to explode in New York's Times Square before fleeing and boarding a flight at JFK Airport to go to the Middle East. Authorities were able to identify him in large part because of the PNR information associated with him on previous flights. Again, another good reason why retention is incredibly important. We need to have the archives available so that the next Faisal Shahzad is easier to identify based on past behavior. And then in addition, authorities found him on the plane because Customs and Border Protection got the PNR record about the outbound passengers departing JFK. So it was actually the customs officers empowered by PNR data who took him off the flight, not the FBI, not ATF, the sorts of investigators that you might normally associate with a terrorism or explosive investigation. It was Customs. And the reason it was Customs was because only Customs had access in real time to the PNR data that made a real difference in that investigation. And I think what we're seeing in Europe among the member states and among the Commission is a similar recognition of how incredibly powerful this tool can be.
Dr. Burwell, in terms of the European underpinnings of privacy law, and also as Ambassador Sales just pointed out, the recognition that Europe has been a victim of terrorist attacks recently, and this, of course, is why they adopted their own PNR requirement. In some respects, this sounds like a discussion that either is or ought to be going on inside Europe about how they would try to square this circle. What is your sense of how European officials are going to try to figure out a way, if this digital commission is established, how are they going to see their way to in effect working this out in a way that doesn't provoke a transatlantic crisis?
Well, I think it's going to be a real challenge. I think one of the challenges that you have in Europe right now is that you have essentially two communities, two different discussions going on. So you have the privacy people who can be rather, I hesitate to use the word absolutist, but who they are there to protect privacy, and that's their mission. And there is sometimes in Europe a commitment to not having any risk at all in that equation. So whereas you might think about, normally your data would not be subject to US security surveillance unless you can promise that it absolutely will not be subject to national security surveillance. Those are two different things. And that makes it very difficult. Then you have the law enforcement community in Europe, which I think is entirely in accord with Ambassador Sales. And I think that they recognize the value of this and they work cooperatively with US law enforcement. So I think that they are an anti-terrorism. So I think that they are on that same plate. So yes, you're right, in a way, it's something that has to be worked out within Europe. However, the place where the rubber is hitting the road is on the US-EU relationship. I wanted to return just very briefly to the idea of adequacy, because a key element in the way the EU looks at whether another jurisdiction provides adequate privacy safeguards is whether that jurisdiction has a national privacy law. And we do not. We have different sectoral privacy laws like HIPAA, the health law, et cetera. And most of the major US corporations who are involved in the tech and digital economy are now in favor of a privacy law because they understand that it would ease the challenges in in managing data that goes across the Atlantic. So I think that that is one thing that we should consider very carefully, Congress and the administration should consider very carefully, is whether it is time for a privacy law. It doesn't have to be the same as GDPR. It doesn't have to be the same as the California law, but we are starting to head into a place where there will be different privacy laws in different states, and that's not good either. So I think that if we want to resolve this issue and perhaps also take a step forward on the Privacy Shield one as well, a national privacy law could be a great boon. Let me also say that the US has right now, since the Snowden revelations, somewhat of a reputational issue in Europe. There are other countries who treat individuals' data far more lackadaisically, far more very badly, et cetera. But it is often us who is challenged, whether it's by Max Schrems or others. And Schrems being an Austrian privacy lawyer. So I think that that is something that we need to work on, and making the reality, making clear what the reality is. But I think a part of that is getting a US privacy law in place.
Ambassador Seals, what are your thoughts on that question?
Thanks, unmuted now. Let me agree with Dr. Burwell and gently disagree with her on a point that she just made. I think it's absolutely critical that the United States do a better job of evangelizing for itself when it comes to our privacy protections. We invented the Fourth Amendment. Part of the reason why we are the United States and not a colony part of the United Kingdom is because of general warrants and unreasonable searches and seizures. So the United States was founded to protect privacy in a very real sense. And that's true today as well. Privacy is a critical value for many Americans, and it's reflected in our law. And I want to highlight one particular development that strikes me as quite probative of how much purchase privacy values have in the United States, particularly relative to Europe. There was a recent study reported on in Politico about how much more robust privacy enforcement is in the United States than even in Europe. Since 2018, when the GDPR first came online, the US Federal Trade Commission, which is our national level privacy regulator, has imposed fines for privacy violations in excess of $6 billion. That's billion with the B. Now contrast that with the privacy sanctions that have been imposed in the EU, which is just shy of 330 million. So a full order of magnitude greater fines when it comes to enforcement in the US. That's not to say the United States is better than Europe when it comes to enforcing privacy rules, but it just goes to show that we're speaking the same language, but with a slightly different accent. And the United States should get, in my view, a good deal of credit for the mechanisms that it already has in place to protect our citizens' privacy and the privacy of people who come to visit us. The last thing I'll say, and this is where I will gently disagree with Francis, it may make sense for the United States to adopt a national level privacy law. If we do so, it seems to me that the best reason to do it is because the American people think that such a law makes sense for them. It doesn't strike me that the best reason to do it would be to curry favor with foreign governments. I'll stop there. Thanks.
Ken, let me ask you from the technical perspective as a lawyer who's studied these issues very intensively. Is there, do you think, a way of harmonizing the different legal approaches to privacy that the US and the EU have? I take Nathan's point that although there may be specific differences, as Dr. Burwell says, we share common values and perhaps more so than many folks realize. But from a technical perspective, are there ways of either harmonizing or reconciling these differences without the need of a clash that could actually disrupt transatlantic aviation?
Well, first, both my colleague Fran and Ambassador Sales are right on the larger debate about privacy law. I would just add, as one who teaches the subject, that if you ask privacy scholars, they will tell you that the fact that the US will very soon be the last significant country in the world without a comprehensive privacy law is catastrophic. China is going to pass one. India is going to pass one. The perception of that is really a problem in international fora. As to the feasibility of overcoming this, let's remember that Canada has an adequacy finding from the EU, and that reflects the fact that their privacy laws are much closer to Europe's than America's are. Canada has a comprehensive privacy law, has had one for quite a while, but yet the Court of Justice found very specific granular faults in the agreement that was negotiated between the EU and Canada. That shows the difficulty in this area. It shows perhaps that the Court of Justice is looking at this without the law enforcement equities foremost in their minds. Some of the issues are going to be very hard. Ambassador Sales mentioned the period of retention of data. It's clear that EU member states are sympathetic to lengthier retention periods. There's a set of conclusions that are coming out from the European Council soon that stress that point. But the Court of Justice is in favor of almost immediate deletion of data and retention of it for longer periods only in the cases of known criminals. And that philosophically runs in the opposite direction from what Ambassador Sales said earlier about its value in determining unknown connections later on. A second issue that's going to be very difficult is what's called sensitive data, and that is information that's revealing of religious preferences, for example, which is maybe shared under the US agreement now, but which the Court of Justice believes should not cross the ocean. On some other areas relating to oversight and judicial redress mechanisms, I am more optimistic because there is significant hard work being done right now in the commercial data privacy negotiations, in the post-privacy shield negotiations, that I think is instructive and that can be drawn upon in future discussions between the US and the EU.
Dr. Burwell, you've been involved in transatlantic summits as a commentator and outside advisor, and I know Ambassador Sales and as a participant, and Ken as a legal advisor. What are some of the challenges of getting an issue like this elevated to the level where, as you say, Dr. Burwell, you can get a counsel appointed, and then how do you set the terms of reference for such a counsel? I take it as given that there are significant commercial interests at stake in data privacy, and there's often the money talks situation, which those of us who are security practitioners sometimes might wish we had that level of clout. But nevertheless, the level of clout that we have comes in more the enforcement context. But I take one of the lessons from what Nathan has said, that you would prefer not to have to be in a situation where you're enforcing the law. You would much rather have voluntary cooperation. So when we talk about trying to get something set up as a digital commission, what is the sort of summitteering that's involved in getting an issue like this high enough up on the transatlantic agenda that it actually gets addressed at a place like the US-EU summit? And how does that actually unfold?
Well, it's a challenge. And I think it was Bill Clinton who positively hated US-EU summits because one of the big issues at the time was the banana dispute, which had a focus on, excuse my phone, had a focus on the curvature of bananas and whether Caribbean or American bananas would be allowed into the EU marketplace. So that's clearly not an issue that you want to spend a lot of high-level POTUS-like time on. So I think that what you have to do, though, is use that venue, the summit venue, to say, this is an important issue. If, for example, to use one example that my colleagues have talked about here, if Europe goes forward and accepts that data can only be retained until the person gets off the plane or pretty soon after that, then we will have missed these nasty individuals. And only, I think, when you can put it in that framework, do you then get the political impetus from the very top that says, we need to figure out a way that moves this issue forward. Then a council like this one cannot, you're not at the ministerial level going to solve this problem. It will require technical expertise. It will require people like Ken and Ambassador Sales to be working on these things. And I think, though, that it's when they have a reporting deadline to come back for the next council meeting that it helps to get them moving. And also to say, okay, at this point in the negotiations, we need X, Y, and Z from our bosses. So the EU itself works like this in some regards. You have a council, and the council tasks the commission with doing reports. They have that report presented on the date that it was supposed to be presented, and then the next step goes forward, and then recommendations for action, and then action is presented. It can get slowed down, but it's a kind of bureaucratic but unstoppable process. So I think that a council that may come out of the summit, or the summit itself, they're not going to resolve some of these problems, but what they do is they put it in a context, and they say, we need to resolve this because of these larger geopolitical issues. We need to resolve this because it's part of how we as a partnership, as a family, if you will, are going to deal with those outsiders who are addressing things differently. Ken just mentioned that China is working on a privacy law. Well, that privacy law is not a standard privacy law that does not have standards of privacy that we should want to see put forward around the world. So whether or not we get a privacy law, we need to be talking about with the Europeans about what do we want as the rules for the digital economy, as the standards for the digital economy, including how you balance privacy and national security. And we should be putting that forward as something that we want among the democracies.
And then Ambassador Sales, you've also been involved in teeing up these sorts of issues. What's your experience on how something like this actually gets taken up at the ministerial or even the head of state level?
Well, you basically pick up the phone and tell the secretary there's an issue and we better address it. I mean, to be perfectly reductionistic, no, I agree with what Francis said. It's important to explain the practical consequences of a rift or why we need this particular tool and what would happen if this tool were to be taken away or to be modified in a way that reduces its usefulness. I've had those conversations. Tom, I know you have. I suspect, Ken, you have too. I've had those conversations with, I forget how many cabinet secretaries, and in every occasion, the response I've gotten was, all right, let's make sure that we are armed with the information that we need to explain the value of the tool, and to make sure that we don't lose the capabilities that we have right now. If we paint this as just an abstract question of conflict of laws between the United States and Europe, people are going to fall asleep. Panelists, as well as audience members, not to mention cabinet secretaries. If we describe this as, here is a critical national security tool, here's how we used it, here's what we stand to lose if it goes away or is changed, that's the sort of thing that I think gets it on the agenda at a higher rank than the banana curvature discussion.
Well, that's certainly fair enough. Ken, in terms of where the lawyers are in advising on this, is there a magic legal bullet, or is this going to take the kinds of high-level diplomacy and elevation of the issue that Dr. Burwell and Ambassador Sales have just described?
Well, my sense is very much like Fran's and Nathan's, that this needs a push. It is obviously difficult at the technical level. The European Commission has elected for the time being to concentrate on Canada for obvious reasons. But the status quo will not hold with the U.S. indefinitely, and I think because the issues are technically difficult, the lawyers and the career people are not going to leap into the breach until they get a direction to do so. And I say that with respect to Brussels, I believe, as well as Washington, and they are working hard on this set of issues in Brussels, I know, through their internal reflection process. And there's plenty of material out there now through the ICAO work that Ambassador Sales mentioned, as well as other international initiatives. So I remain hopeful that there is a way forward here, but it's not going to be easy.
I want to thank all of our participants and our audience for today's extremely interesting discussion. I suspect, without, I have to say, any actual knowledge of what papers might be in the briefing books, that there is probably a page in the briefing books on both sides of the Atlantic that are being prepared for this summit, papers that address this issue. And if we can pull those papers from the back of the book to the front of the book, then perhaps this event will have served a useful purpose. I'd like to thank Ken Propp for having given us the benefit of his legal and other expertise in terms of how these agreements work and how they are functioning. Ken is the lead author on an upcoming Atlantic Council issue brief on this subject that we will be releasing shortly after today's event. I'd like to thank Ambassador Sales for his service in departments of Homeland Security and State, and his contribution to our discussion today with his perspectives. And then also Dr. Fran Burwell, who has provided the benefit of her experience resolving transatlantic issues and showing that there is, in fact, a path forward, and indeed several paths forward that can head off a potential crisis in the differences that currently exist over passenger name record data. So with that as our conclusion, I want to thank everyone for joining us today, and we invite you to come back to a future event as we discuss some of the other issues connected with the transatlantic relationship. Thank you very much.